All right. I hope everyone's with me here. I appreciate everyone joining, and it's odd to give a law lecture because I have hung up my my lawyer's robe over the last couple of years, and I am now in politics. I guess to start, I just want to give a little bit of a background of who I am. So my name is Nathaniel Erskine-Smith. I'm a Member of Parliament in Canada for a Toronto area riding, Beaches East York. If you're ever in Toronto, please let me know. A very brief background. I grew up in the area that I now represent. I live here now with my wife, and I've got a year-and-a-half-old McKinley as well. My parents are in the area, so I'm very lucky to have an opportunity to represent the area where I grew up and represent my community, my neighborhood. I got into politics and law through my studies. So I studied politics at Queen's University here in Canada. I studied law here at Queen's University in Canada. And I subsequently moved on to do my Master of Laws at the University of Oxford in political philosophy and constitutional law as well. And when I returned from Oxford, I practiced law for 3 years before jumping into politics. And so I guess in sum, I would have had 2 summers of at a larger firm downtown Toronto in between law school. I would have had an articling year before I got officially called to the bar, and then I would have had 3 full years of practice at a smaller firm downtown Bay Street here in Toronto. And my practice was commercial litigation, so it was about winning cases. It was about shareholder disputes, breaches of contract, employment matters, fraud matters. There weren't, basically no. There were occasionally negligence issues, but fundamentally we weren't dealing with insurance and personal injury cases, and we weren't dealing with criminal cases in any way. So what I want to talk about today is really briefly, and by the way, I'm happy to answer any questions about politics and or law. So what I really want to get at today is how you ought to think about the case when you take on a case, how you ought to think about winning a case when you take on a case. So first, and you'll get into basic procedures. We'll get into the different steps in a case. But the fundamental question that you have to ask yourself, whether it's someone that comes to you with an injury, say they were hit by a car, whether it's someone that comes to you with a breach of contract, to say that they're going to lose millions of dollars, what is the fundamental loss or wrong that you are to rectify for your client? And once you start thinking about that, you quickly identify what kind of law you need to use to tackle the problem. So in the case of contract law, it can be quite obvious in some cases where there's a written contract, but there are instances of unwritten contracts as well that you want to consider. There's tort law in relation to negligence, which is very common across the board, or intentional wrongdoing in some cases, assault or battery, or much rarer, but also tort outside of the criminal context. You might want to consider in the business context, is it a shareholder dispute, in which case you're dealing with particular remedies and oppression remedies. In some cases you're dealing with particular statutes. In Canada and in other common law jurisdictions, there are oftentimes particular statutes that set out in principle the oppression remedy, and then case law has fully developed the specific factors and considerations. Is it between franchisee and franchisor? So if the dispute, it's a contractual dispute, but oftentimes there's additional legislation imposed upon these relationships, in part because there's a power imbalance, and to impose clear, specific good faith and disclosure obligations. So you might want to consider whether it's fraud. There were a number of cases that I had the occasion to deal with. It was one case in particular stands out, where we had a series of clients who had been ripped off to the tune of $13 million and they were out to get their money back, and the individual who had declared bankruptcy, on the eve of bankruptcy, he had transferred a number of assets. He had continued to have a hidden credit card where he had buying his wife Versace jewelry and taking wonderful vacations. And we wanted to not only get at the money, but to the extent that that money was hidden, the easiest thing to do was to undo the transfers and to claim that those were fraudulent conveyances. And so to prove fraud and to prove fraudulent conveyances, there are again a series of factors. And so you have to consider what is the problem, because there's going to be a body of case law to address particular problems. And while there are commonalities across different fields of law, there are differences that need to be considered. So that's the first step, is, just to throw the last example out that I had the occasion to deal with, is defamation law. And so again, there's a wrong to address, in this case harm to reputation, and there's a specific body of law to address that. So first, what's the wrong? Second, what's the remedy? And so before you get to drafting anything, before you get to thinking about winning anything, once you've identified the wrong, you want to know how to fix that wrong. And again, there are a series of remedies, and it really depends upon what the problem is and what the case law as it relates to that problem is. You are going to have different remedies available to you. So in the case of contract law, which was the bread and butter of a commercial litigation lawyer such as myself, you're talking about monetary damages where there has been a breach, and you have the opportunity not just to get the money back that you put into a particular deal, you potentially have the opportunity to get more. How much would you have made if the contract had been completed? And so it could go over and above just getting your money back. So that's the first one, and that's the most common, is throwing monetary damages into the mix. Restitution would be more akin to just getting one's money back. Rescission is to say the contract should never have happened in the first place and to put me into my original position. And that can be difficult to do, especially where there is already performance in part. But particularly in cases of fraud, or in the cases of franchise where there has been a failure to material disclose key information, then certainly rescission is an available remedy. Specific performance is really not very, I haven't seen it very often in the course of my career or in the course of the case law, but it's when money is inadequate. And, in another example, in the case of different kinds of relief and different remedies. So we often dealt with, in my world, shareholder disputes, and we often dealt with, think of it like corporate divorce, where people are in a business together and they're shareholders, they're directors together, and then things go south and they're not getting along, and one person does something untoward towards the other person, and the idea is to pull the interests apart, and have, oftentimes the answer is to have one person buy out the other. And there are questions about what's the fair value, there are questions about who ought to do the purchasing, but certainly in an oppression remedy case where you can prove that the other person unreasonably disregarded your client's interests, then oftentimes the election will be up to your client as to whether to buy out the interest or to have their interest bought out. But again, you got to think about what the available remedies here are. And then finally, is there an interim order that might be useful? So in the case of defamation, to take something down even before you've proven that there are damages to be earned. In the case of a shareholder dispute, to stop a particular practice of excluding a decision maker from the board, or to prevent a company from proceeding down a particular path in the interim. You can think of an injunction where we're occasionally demanding that a company or individual do something, but more often saying, don't do this because there will be continued harm. And again, you've got to think about, is there an interim remedy that I want here before you start drafting your materials? Now, the process. Okay, so this is, I don't know to what extent you guys in the law school have learned this already. I will be brief. And by the way, I'm happy to answer any questions along the way. So I recognize we're doing Facebook Live here, and I'm not sure if any questions have popped up yet, but do post questions in the comments. I'm happy to answer any questions along the way, and I'm happy to answer any questions about law or politics. So think of it really simply. You've got the pleadings, so you've got your statement of claim, you've got your statement of defense, you've got a potential reply as well, and in every jurisdiction there will be set timelines to get those out. You're going to have to serve the other party, and that's one thing you quickly learn in the course of law, that there's a lot of law you learn in school on the books, but serving people can be so difficult, and getting notice of that service before a court is key. So you've got the pleadings, you've got a discovery process ultimately, and we'll get into communications as a lawyer, but the key thing to keep in mind is everything you write as a lawyer in the course of a conflict is likely to be open to the discovery process and is likely to be ultimately read by a judge if it's relevant or particularly damning or undermines your case in any way, so or shows you in a negative light. So be very careful what you write. The discovery process in Canada is or in Ontario, I should say, in my jurisdiction, but I think it's across the board common in common law jurisdictions, the test is relevance. And so you have to disclose every document, if it's a damning or explosive email from CEO to the CFO, it's to be disclosed. Everything that is relevant, no matter how confidential seeming, must be disclosed in the course of the discovery process, except if it's correspondence as between you and your client, or if it's correspondence between you and other lawyers at your firm, or in the course of litigation prep, once litigation is already set. But if it's pre-litigation, if it's not between you and your client, if it is just in the ordinary course of dealings of that business, everything has to be disclosed that is relevant to the case. And you oftentimes will see fights where companies don't want to disclose everything, or individuals don't want to disclose everything. And so what you end up seeing is you see a lot of interim motions to deal with this, to say you must provide this document, you must open up this box and deliver these documents to us, and you'll have courts oftentimes weigh in on what has to be disclosed, and the whole process can become very long and bogged down. And we'll get to some of the strategy of bringing motions. Oftentimes the very well resourced party who has deep pockets and can spend a ton of money on litigation, if you're up against, if it's a David and Goliath situation, Goliath can spend a bunch of money and bury David in paperwork and motions, and particularly discovery motions, and slow the whole thing down and really make it difficult for David to access justice and to see the case through. And if at best for David, often forcing him to settle. So, statement of claim and pleadings and defense. Statement of defense, we've got a discovery process, and the discovery process is both a written discovery process, so documents. You are also in a position to ask to interview the key or one representative, typically from the defendant corporation or the defendant himself or herself. The opposing party will also be in a position to discover or ask questions of, and it's not in a court typically in Canada, it's typically in a boardroom, and you have a court reporter taking notes, and so you get a verbatim transcript of all the questions that you've asked and all the answers, and they are it's all admissible in court. And so that is the foundation of the case you end up building. You want to find all the written relevant documents, and you sift through those to find the key ones to make your case and build the evidence for your case. And you want to make sure you're asking every important question and relevant question of the opposing party. And in some cases, you might have third parties attend who have information as well. And you're trying to build the case before you're in a court of law. So when you do get to court, you you know the case. There are not going to be any surprises, and you're going to make the case as best you can to the judge. So you have case outside of the discovery process. You have case conferences, oftentimes settlement conference with a judge, not the judge who will be hearing the case in the end, and they will often push parties to settle or not to settle. They will really pointedly point out your weaknesses, and they will point out your strengths to the other party, and they will try to badger both parties into settling, and the vast majority of cases settle as a result of this process, not just because it's expensive to litigate something from the beginning to the very end, but also because the settlement process, the settlement conferences, you have a mediator or usually not oftentimes a retired judge that is encouraging settlement and pointing out strengths and weaknesses for both parties. And then if you get there, and very rarely do you get there, you have a pretrial conference and then a trial. And I have seen trials in the course of my short career, but not too many. And they are rare and rarer these days in Canada and in Ontario at the moment, but I think it's a problem in Canada across the board. We see trials, to get a date for a trial is years away because our court system is so backlogged, something we certainly need to address. The last thing I would say is, so we have interim motions, and I mentioned that you could have an injunction motion, you could have a discovery motion to get documents. You can also have a motion to determine the whole case. And so one thing to think about when you're drafting your pleadings, you can start by way of you can proceed by way of a trial. You can also proceed by way of an application. And an application is akin to a motion. It's all in writing. You don't have the same trial where you put someone in a box and you cross-examine them, and you're and you bring in witnesses in front of a judge. It's all on the paper record, and you argue in front of a judge. And the idea is, with an application, it's certainly cheaper, it's certainly faster, it's certainly more convenient for the parties, and you do it where you're determining an issue of law, or you do it where you are determining an issue where the facts are not particularly in dispute. Because as soon as the facts are in dispute, you need individuals to attend before the judge and answer questions before the judge, and the judge will then have an opportunity to address or to assess credibility and to make a final determination on that. Okay, so I briefly mentioned this, but communications as far as counsel are concerned. So it's a dispute, and we're human beings, and I have seen so many emails from lawyers that are quite nasty, that are written without great thoughtfulness in advance, and certainly without putting pause and just sent off in the heat of the moment. And that can undermine your case, because at the end of the day, it's all about persuasion to the judge, and every document that goes before the judge will either improve the standing of your case or has the potential to improve the standing of your case or to undermine the standing of your case. And you do not want a judge to see a nasty email that you sent off to the opposing party or opposing counsel. So I think this generally ought to be the case in terms of the way we conduct ourselves as lawyers, and it goes for our written correspondence as well. We have to be tough, there's no question, but we also have to be respectful. And when we communicate with the other side, be clear, put everything in writing, and make sure we do not send things off in the heat of the moment and take a particularly aggressive tone or turn it into a dispute about us as advocates. It's about the case. And I say always follow up in writing. So this is incredibly clear. There are so many times where you might have a conversation with opposing counsel or with another individual, frankly with clients, because client management can be one of the most difficult things in winning a case. And every single time, I can't stress this enough, every single time you have a conversation, verbal conversation with opposing counsel, with your client, with anyone regarding the case, you follow up in writing and you say, further to our conversation, and you set out what was said in bullet points or whatever the easiest thing to do. And what that does is it guarantees that unless they correct that information, now they might correct that information and then you can go back and forth and make sure there's a meeting of the minds on that, but unless they correct that information, then for third party down the road who's going to review this correspondence and potentially resolve a dispute, incorporating this correspondence into the evidence, that this is going to look like what the conversation was. And so make sure it's truthful. Make sure that's exactly what was said, because you certainly don't want to lose credibility in front of the judge. Or, as an advocate, you need to build up that credibility, not only in the case but over time. But make sure that you put it in writing. There's of all the lessons to take away, there's nothing more important than after every conversation of substance, follow up in writing and set out exactly what was talked about. Okay, the last thing I want to cover. I mean, I'm certainly not going to take 2 hours of your time today. The last thing I want to cover is, and before we get into questions, and if we don't get questions on Facebook Live, I might have to call Nafeez back, and maybe the audience directly can ask questions of me. So, writing. And I've been taught this from sitting judges, and I don't think there's anything more important in terms of persuasive advocacy. The vast majority of, this is another incredibly important consideration to keep in mind. You might think you're going to go into court and you're going to convince the judge with your eloquent style, and politicians particularly think that we're good on our feet and we have powers of oral persuasion. But the fact of the matter is, the vast majority of cases, the vast majority of times in those cases, judges have already made up their minds, for the most part, on the written record, because they've got a factum, a written argument that's been delivered to them. The factum makes reference to various documents in the brief that's been put in front of them. The factum makes reference to case law, and so they've read the best foot forward that the advocate has. And if the advocate's just going to go into court and make the same argument verbally that they've made in writing, well, the judge is already going to understand it, already going to know the holes in it, already going to know the strengths of it. And so in the vast majority of cases, they've already got a very good sense of where they're going to decide before you've even stepped into that courtroom, based solely upon the written materials. So you damn well better make sure your written materials are as good as they can be. And to that end, here are a few key rules, okay? 1, master the evidence. So have a complete and total control of the evidence and an understanding of the evidence. Make sure you are addressing all facts, both good and bad. You don't want to ignore bad facts. You actually want to address them head on in many cases, and to soften their negativity as best as you can. 2, and I mentioned this at the outset, but it's the same in written advocacy as it is in just considering strategy. What's the problem you're trying to address? I mean, judges are practical problem solvers. So what is the problem you want to address? And reverse engineer it. Take it from the solution that you want back to the problem. And how do you want the judge to get there? And set that out. You want thematic organization, I think, more than anything. You want to set the case out into key themes. It's not just, in some cases you're going to turn to chronology, but the more it's, on this day this happened, 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 you're going to bore and lose decision makers and judges. So you want thematic organization, the key themes of the case and the key issues that are before the judge. You're going to want to write way less than you think you need to, okay? And that starts with point first writing. So in every case, don't lose the point. The point should be up front, center. Judges don't have a lot of time. Judges are overworked. They've got a ton of cases in front of them at all times. They hear many cases throughout the day. You need to be direct, clear, concise, and put that point for every paragraph that you want right up front, and then build the evidence around that point. Basic things like white space on the page is important. It sounds silly, but it's incredibly important for human beings to take in information. So you don't want to jam too much information onto every page. Organization of headings and subheadings, ordering the sections. They seem simple, but you're talking about a way of framing information to make it persuasive. And so it's incredibly important that you're presenting it as best you can. And then really think of, I mean, judges are human beings, so you're obviously pulling upon the logic of the case, and you're pointing to case law, and you're saying this clearly follows from the arguments that I've made, but you're also pulling on people's emotions. I mean, at the end of the day, there are, in employment contexts, even in commercial contractual disputes, particularly, what I saw firsthand was shareholder disputes. Emotions are high, and you want to show the judge that your client in the best light, and you want to show them why your client deserves justice. And to the extent you can use emotional arguments, you shouldn't shy away from that. Okay, so the last thing I want to say is just about interpretation, and it is obvious what the law is in many contexts. Okay, so sometimes there's no argument about what happened or what didn't happen, or whether you were consistent with the law or not consistent with the law. The law is written clearly. So if a law says no cars in the park, okay, that seems obvious enough. You can't drive your car into the park. What if the law says no vehicles in the park? Okay, now, you obviously can't drive your car into the park, but can you drive your bike into the park? Probably. And then it's a consideration of what was the purpose of the rule to a reasonable person. And so when you think about interpretation, and case law matters, so think of it this way. You've got the text of the statute, that's your starting point. And to the extent there is, two things. To the extent there is any ambiguity in the way that could be read, so say vehicles, what is the range of vehicles? Well, oftentimes there are going to be cases that determine that. And so you might go to the case law, and you ought to go to the case law. And the case law is a supplement. It is as much law in many ways as the statute, and it supplements the statute. And that might give you a very clear answer. You might have had a judge decide, yes, bikes are vehicles, or no, bikes are certainly not vehicles for the purpose of this, and on you go. But if you don't have that, or if you have a judge that says rollerblades are obviously not vehicles because of X, Y, Z, then you might make an argument based on analogy and say, well, this case decided this, and so for the same for bikes. The key here is you start with the statute, you move to the case law, and if there's clarity in the case law, you move forward from there. And if there's still not absolute clarity, you make an argument based on the purpose, a purposive approach, and really the principle that you're getting out of why do we have this law? Why not getting into the minds of the drafters, although sometimes that evidence is useful. Fundamentally, the question is how or why is this rule on the books, and what's the purpose of the rule? And that's to a reasonable observer, i.e. the judge at the end of the day, and you interpret it from there. And so while it's sometimes very clear, to the extent that it is vague, you want to get at the purpose of the statute and the various principles that might underlie it. And in some cases, in the case of take contract law as an example, you might want to go back to first principles of questions of freedom to contract, questions of fairness as between the parties, questions of is there a power imbalance between the parties. And you oftentimes see little tricks and little rules develop over time based upon these core first principles, where, to take an example of the power imbalance, there's a rule in contract law where one party drafts the contract and there's an ambiguity. It's interpreted where there's a dispute between the two parties. It is interpreted against the drafter. because it's the drafter who had the power to have their lawyers draw it up, and so rules develop based upon those more fundamental principles. Anyway, so I think I've covered on the legal side most of what I wanted to cover for today. More as a broad overview of what you look for when you start to litigate, and I'm happy to come back another time. I'm happy to do a series of lectures that gets into more detail about each sort of step and the rules and the various case law examples to point to for different remedies in contract law, different examples of good pleadings, bad pleadings. But for today, I really just wanted to stick to more generally the principles and the higher level processes and considerations to keep in mind. So I appreciate everyone hearing me out. And since I don't, I'm doing this for the first time. Since I don't have, I don't see questions on Facebook Live, I'm going to finish off here, and then I'm going to call the class back and see if there are questions there.